Good morning, everyone. We're going to call to order this August the 22nd, 2019 meeting of the Alarm Systems Contractors Board. We want to welcome everybody that's present here today. Ms. Bess, will you please call the roll?
Thank you. Scott Cockcroft.
Here.
Lou Richard.
Here.
Vivian Hickson.
Here.
Doug Fraker.
Here.
Keith Harvey.
Here.
You have a quorum, Madam Chair.
Thank you. Have the members had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt as presented?
Motion to adopt the agenda as proposed.
Second.
Okay, we have a motion to adopt by Mr. Fraker, a second by Mr. Richard. All in favor, voice by saying aye.
Aye.
All opposed? The agenda is adopted. Now, we have the minutes, but I understand there are some corrections that need to be entered into the record.
If it's okay with the board, we would like to send these back. There are more than just several corrections that need to be made, and then we can present them to be signed at our next meeting in October, if that's acceptable to the board.
It is. Do you want a motion on it, or just? Please. Okay. Okay, we need a motion to pass these minutes until the October meeting, please.
So moved. Second.
Okay. We have a motion by Mr. Harvey, a second by Mr. Cockcroft to pass the minutes from the June meeting to the October meeting for review. All in favor, voice by saying aye.
Aye.
All opposed? The motion's passed. Okay, Mr. Gentry, our legal report.
Thank you. Good morning. We'll start with number 1 on here, which is 2019-041511. The summary is that the complaint originated as a billing issue and concerns that complainant said his alarm system was faulty. Respondent responded to the complaint and said all billing was done, or all billing that was done was for services rendered and that the system was working appropriately. Complainant later disclosed the alarm system was for his rental property in Texas and not for the one in his home in Tennessee. Additionally, respondent has multiple active licenses in Tennessee, so there are no valid concerns of unlicensed activity. I put that there because if you see in the heading, it says that their license had expired. They have a few licenses, and our investigator was able to confirm all of that. So the recommendation was to close.
With council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Fraker to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, so we have number 2, which is 2019-03-4691. The summary is the complainant alleged that respondent called her in November of 2017 and told her that if she signed up for their alarm system services, that she would receive $50 per month off of her TV bill for 3 years. Complainant did not have anything in writing to confirm this credit. Complainant later noticed that her TV bill had not changed, and when she called her TV provider, they stated that they did not have any agreements for discounts with any security system providers. Complainant contacted respondent on October 11th, 2008 to cancel her security service and contacted her bank to stop all auto withdrawals to respondent on the same date. Complainant said respondent has since contacted collection services to collect balances owed to respondent. Respondent provided copies of the contract agreed by complainant, and there was no language about the credit towards her TV bill in that contract. The contract was signed electronically by complainant and showed where she was emailed a copy of it as well. The recommendation is to close.
Motion to concur with council, but also notify the complainant that that's more of a civil matter than a board matter.
Motion by Mr. Harvey. Do we have a second, or do we have questions?
I'll second the motion.
Okay, we have a second by Mr. Richards, or Mr. Richard. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
The decision would be to close with that email to the complainant.
That's correct.
Okay, thank you. I just wanted to confirm. Thank you. Next is number 3, 2019-046-851. The summary is the complainant was in a contract with the company respondent that it merged into. The named respondent is no longer active and complainant's contract is with the other company. However, the issue at hand is that complainant attempted to cancel his contract for alarm services by phone. He was then sent a letter that directed him to take a specific action depending upon the reasoning for why he was canceling his services. The complainant did not follow the steps as he stated he felt it was a stall technique by the company. However, this led to the complainant having services longer than desired. The letter and request by the company do not appear unethical or fraudulent as they appeared, as stated, to fairly calculate any remaining fees or balances owed pursuant to the contract. Complainant was able to have his contract canceled despite never filling out the correct paperwork. The recommendation is to close.
Make a motion to concur with council to close the complaint.
I'll second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Fraker to concur with our council's recommendation to close. All in favor, voice by saying, all in favor, voice by saying aye.
Aye.
All opposed? The motion passes. Now, it shows the the license is expired. That's on the original respondent, not the new company, correct?
That's correct.
Okay.
Mhm. It was confirmed by our investigator that they actually have an active license. Mhm. Number 4, it's number 2019-01-9311. The summary is the complaint alleged that respondent assumed an alarm services contract between a different company and complainant. Complainant stated he initially contracted 18 years ago with the company to provide alarm monitoring services for complainant for $100 per quarter. Complainant was notified approximately 6 years ago that a new company would be taking over the account and that it could enter into a contract with this new company if it wanted to keep its services. Complainant entered into this contract. Then in 2018, complainant received a bill from respondent for its monitoring services. Complainant stated it never received notification of respondent taking over the account or any type of request to enter into a contract with respondent. Respondent was billing complainant for $400 per quarter instead of the $100 per quarter that it was paying previously. Complainant stated it was disappointed in the matter in which it had to cancel its services. However, respondent agreed to cancel the contract without charging an early termination fee. Respondent did not respond to the complaint. However, it appears the complaint may have never actually been sent to the respondent due to an incorrect address being associated with respondent in the actual complaint itself. The recommendation is to close.
Not sure I followed all of that.
I'm not either.
No, that's fine. I can explain anything. Do you have specific questions or?
So they did sign up with the new company? It sounded like they did, and then they said they didn't.
They said everything that they told me was that no, they did not. They had signed a contract with the first company 18 years ago. Then about 6 years ago, they signed with a second company, and the respondent in this one is the third company to actually have
Ooh,
services.
okay. That's
So-
what I didn't understand.
Mhm. So they had gotten an invoice from this third company. My understanding is this third company actually purchased that second company and assumed those contracts.
It does sound like it's kind of doesn't matter at this point since they have, it's resolved to the complainant's satisfaction, correct?
Correct. Albeit their disappointment, they stated.
The only problem then is that it didn't respond, but you are confident that we sent it to the wrong address.
I am actually, and we had sent another, this is something I may have to talk, with Executive Director Vest about. We have a few different addresses and license numbers for this respondent within CORE, and I don't think it's an issue where they haven't updated us. I think it's more of an issue when the complaints are actually being filed. When they're being open, they're looking at the old information.
Make a motion to concur with council's recommendation to close.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Harvey to concur with our council's recommendation to close. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
First, we have number 5, which is complaint number 2019-033521. The summary is the complainant came across respondent's advertisement to hire a customer service representative / field technician in Tennessee to provide, quote, support to customers with all their security and identification needs, end quote. Respondent is not licensed in Tennessee and stated it is not an alarm systems contractor. Respondent stated it manufactures photo identification, visitor management, and access control software. Respondent stated it does sell its photo identification and visitor management software to customers in Tennessee, but it only sells its access control software and hardware to one authorized licensed vendor in Tennessee, who then sells, installs, and services this equipment directly to the customers. Based on a review of the capabilities of the products of Respondent would not need an alarm license for its photo identification and visitor management software, as this software does not perform any activities that would require an alarm systems contractor license. The access control software and hardware does require the installation of internal wiring and would require Respondent to be licensed if it was selling it to customers. However, as Respondent is the manufacturer of this equipment and sells it to a licensed vendor who does all of the contracting with the end users, Respondent is exempt from having a license for this equipment. Respondent stated that customers contract directly with the authorized vendors for the sale and installation of their products. Respondent apologized for any confusion, explained that the advertisement was to hire an individual who would assist customers with the photo identification and visitor management software. Respondent denied performing any unlicensed activity, and the advertisement did not clearly state Respondent was providing any unlicensed activity. The recommendation, therefore, is to close.
Make a motion to concur with council's recommendation.
Second.
We have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, next we have 6, which is complaint number 2019-043561. The summary is the complaint alleged that Respondent entered into a contract with a large corporation to provide installation and monitoring of alarm systems at several of its locations in Tennessee. A former employee of complainant was contacted to assist Respondent with the installation at some of the locations. This individual stated the installation started in June 2018. Complainant owns a business that lost multiple contracts to the Respondent. Respondent claims it does not do any activity that would require a license. Respondent says it has no offices or employees in Tennessee, has a licensed contractor do all monitoring services, and has licensed contractors do all installation and servicing of the equipment. According to Respondent's website and bid sheets it provides to subcontractors, Respondent appears to contract with customers and advises them as to their needs, and then contracts with licensed installers to install equipment provided by the Respondent. Respondent claims that it does not sell equipment or services, nor does it advise customers as to their need for services. However, all initial contracting between customers and Respondent would likely include this information. Additionally, copies of blueprints provided to the licensed contractors for bids for installation show Respondent's requested equipment to be installed, as well as plans for where the equipment is to be installed. Respondent claims that these blueprints and plans are created from their out-of-state office, sent to clients for approval, and then sent to licensed contractors for bidding and installation. Respondent claims that since it is not going to actual locations, drafts the installation plans online, and sends the plans out to licensed contractors, it is not performing sales or advising customers in the state of Tennessee, as it is doing this work from its out-of-state office. The recommendation on this is to set for discussion. I've received a few more affidavits as well from some of these contractors. It's I think it's a better decision for the board to make based on the facts.
So the respondent has got plans to these facilities and is actually designing and
So
sending to his subs.
according to an affidavit I got yesterday from one of the subcontractors, it appears potentially that the subcontractors, or that there's another contractor going to the locations to actually look at the actual needs, or if it already has a system, just to provide the monitoring to a licensed contractor. It seems like the monitoring aspect of it may be covered, since there is a licensed alarm contractor providing the monitoring services. The main issue appears to be whether or not the installation, whether they're selling and installing or advising and selling these systems.
You say there's a licensed contractor doing the monitoring. Are you talking about a third party?
Yes.
Because that doesn't meet the requirement for the person that's selling the monitoring to the end user. The respondent in this still needs to be licensed, even if they're using a third party to do monitoring.
And that's where I think that's maybe more of a minor issue in this, since it's a situation where, and we've actually had previous complaints. I've gone through the previous investigations, because this investigation yielded a lot more information than the first time we sent an investigator out. The very first time when we looked at it, all of the systems on the actual alarms, the boxes, had respondents' information and contact information. However, this time they sent us these invoices where they're saying, no, it's directly through a licensed contractor to do all of that actual monitoring. So that I think is still an issue. The main issue, I would think, would be whether or not they're advising and selling the services.
And in the response, it does say that they're designing. Was that from them, or was that some conclusion that y'all made?
So that came from the complainant. The complainant, his employee, who was then contacted to do some installation services, was sent these blueprints, and the blueprints themselves showed, where the alarms were specifically going to be installed. So at that point, it was the blueprints coming from respondent going to the contractor. So the concern is who is actually receiving these blueprints. Were the blueprints designed by respondent? I sent a copy of those to the respondent, and the respondent's response was then that affidavit I got last night, which was that there's a contractor who's licensed, who's going out to these locations, looking at what the needs are, advising to those, contacting respondent, telling respondent that these are the systems that need to be installed.
Sounds like they're kind of changing their answer, but nonetheless, it seems like there's several aspects there that they're providing the monitoring, they're selling the system. It seems like they were designing the system. Maybe they're saying they don't now. They would still have access to those records. Even if they don't design it, they have access to what design their contractor's doing. To me, it's a clear violation that they should be licensed.
I would agree with your statement, Scott. Sounds like a lot of sidestepping to me.
What would our typical minimum, $1,000?
By the statute, it'd be $1,000, could be unlicensed contracting, alarm contracting, maximum of $5,000 per violation.
Violations can you document?
I think that there's at least one in terms of that advising because of the sets of blueprints. Now, that's another issue as to how many there would actually be, because technically, if we're going to say that there's the monitoring services, if we're going to say there's the advising, the installation, if that's actually being performed, by a licensed contractor, I don't know if we're going to be able to to prove that aspect of it. Because when I look at the actual statute, when it talks about selling and installing the services, I think that they may be around that. I think we have under subsection K that no person shall advise anyone as to the need, quantity, or quality and sell the systems unless certified. I think that's where our clearest violation is.
So then I have to bring up, we have national companies that has locations all over the country. Corporate America, or corporate puts the plans together, sells the system for all practicality, and then hires local licensed people.
But they're both licensed. The national company is,
Well, not always.
you're suggesting they're, well, maybe that's what this is.
And I think that's
And I
where,
would suggest that they should,
'Cause-
someone should turn them in, and
and then, are they actually the designer, or are they a fulfillment? Because we run into that. Fulfillment companies, they're looking for people to go out and do this job, and they're not really the designer.
I think with their stances, what they're trying to say is that they're fulfilling this need. It is to your point of a large corporate, because the client in this specific instance is I wouldn't say a multinational company. I know it's at least large in the United States and has offices. And I would imagine their buildings are pretty standard that you could potentially
Cookie cutter.
you could cookie cutter every single alarm system for every store, because it's in every single state you're having similar designs. But that's the issue. I think they're trying to say that they're just fulfilling this contract, but they're doing it from their out-of-state office and finding the people in Tennessee to do the actual installation.
In general terms, what type of business is the respondent in? Because it says respondent claims that it does not sell equipment or services, nor does it advise customers as to their need for services.
When you look at their website, their website basically says that they're an alarm contracting service, that they can find whoever you need to do monitoring and installation. They don't necessarily delineate that they're going to find, a subcontractor to do that, but that is what their website says.
I'm lost. I'm simple, okay?
No, you were.
What type of business is this respondent in?
So they claim that in the state that they're licensed in, which is not Tennessee, they're only licensed in one state, by the way. They claim that in that state, they're a licensed traditional alarm contracting company, alarm services contracting company. They state in Tennessee that the only services they provide basically are that these corporations need services. They need to find someone to do their monitoring, their installation, their servicing, and they basically find that subcontractor to do that work.
But didn't we say that they've got blueprints and they are designing systems? That's unlicensed activity to me.
Yeah.
And that's where they're and that's what I'm saying. That's where they're trying to basically split the issue. Is they're saying that, and that's what that affidavit I got last night, which was convenient. That I got that said someone else actually goes out, advises as to what's needed, tells respondent's the middleman who then finds the person to do the installation.
So what we think now is going on is that this company sitting somewhere else has taken this basic design and said all 100 of these stores are going to get this system. Here's somebody in Tennessee, take this system and go put it in Tennessee or in Virginia.
I think we either think that could be happening, one, or two, if we were to believe this affidavit, that they specifically send someone else out to actually do the advising and then contact them to then find the subcontractors to bid on what work that would be done. I can tell you from the previous complaint as well, looking at the businesses, they're all, again, multi-state businesses that are involved. We're not talking about at homes or very specific local businesses.
They use the term subcontractor.
I think they use the term licensed contractor is what they said. I don't know if they ever said subcontractor.
Subcontractor would imply they're the contractor.
That's true.
It really gets back to, is the end user paying the respondent or not? Or if the end user is ever writing a check to the respondent for these locations, in my mind, it's a violation.
That's my understanding, is that that's who they're billing on that. And that goes back to the issue of when they have to call for services, the sticker is right there on the alarm system where you call respondent and they figure out who needs to go out there and do it.
If there's a sticker on a site in Tennessee,
Right.
that would.
And this was we didn't see that in this specific investigation. Our investigator was not able to actually find that aspect, but that was on the previous one. So just for comparison, I was bringing that up.
I make a motion to respond with, I don't know how to word this, as far as unlicensed activity with a civil penalty of $1,000. I need to cite the
$1,000. Okay.
What is the TCA
For a civil penalty for this? Well, if we're
violation?
I would think the violation would be under.
License activity statute is 6232-320, I believe.
I was going to say under 304K, which would be the no person shall advise anyone as to the need, quantity, quality of alarm systems.
Would it actually
And
fall
sell
under
the
both of
systems.
them, you think?
Yes, because I think that leads to it being the penalty for violating 304, and then 320 is where you get the $1,000 from.
So when we word our motion, should we cite both of the TCAs to cover it?
Yes.
6232-304K and 6232-320B.
Violation of both of those.
in violation of both 6232, 320B, and 304K for violation of and sales and
Unlicensed activity.
unlicensed activity.
Yes.
I make a motion.
Trying to get a little bit more strong.
I make a motion.
You want my notes here?
Sure.
There you go.
I make a motion for a $1,000 civil penalty for unlicensed activity for 6232, 320B, unlicensed activity in design and sales and advising. Second.
Okay, we have a motion by Mr. Cockcroft and a second by Mr. Richard for violation of 6232, 320B, and 6232, 304K for unlicensed activity, advising and a civil penalty, authorized civil penalty for $1,000 and administrative hearing. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. No, does that kind of cover
Where's Ken
everything
when
we
need to
need?
make a motion?
I think it does, yes. Next, we have number 7, which is number 2019044921. The summary is the respondent advertise on Facebook and through a website that it performs alarm installation and monitoring. Respondent does not have an active license. A Tennessee Department of Commerce insurance investigator attempted to locate respondent and investigate these allegations. The investigator was able to get a telephone number and an email address from respondent. However, the investigator could not get a physical address for respondent or get respondent to meet with him. The most the investigator was able to obtain was confirmation that respondent received his email. There's no evidence that respondent has performed any installations or is monitoring any alarms. However, respondent's advertisements are for installation and monitoring. Due to not being able to get personal service on respondent and respondent not possessing a license, there will be little likelihood of successfully being able to punish respondent for violating the program statutes. Therefore, this case should close as respondent has not been served with the complaint and is unlikely to be served with any further notice of these violations. So the recommendation is to close.
I understand that there's limited amount of what you can do, but it is disappointing. It's frustrating for the complainant. It's frustrating for other licensed contractors. There's not any further way for us to find out who this is or try.
We sent the investigator out to, one, personally serve him, as well as to try to get statements from him, and he was unable to do anything with that. The most we could see basically was there's a Facebook page out there. And
Are they continuing to advertise?
I believe last we saw that the Facebook page was still active. He did not remove the Facebook page.
So if he's still active Facebook, we can't physically find him to confront him.
Correct.
Can we notify him via email, since we do have that information, and a phone number, that he is in violation of state law?
We can do that and send almost like a letter of warning to him.
A letter of warning that you
And that would
need
be
to take
better.
this Facebook page down, or
Cease and desist.
cease and desist, get a license. It's not that
Is there a
hard.
name associated with this through Facebook?
I believe it was a business name. It wasn't a personal name, no. It wasn't a registered business either, so it's one of the
Out of his house,
Right.
out of the trunk slammer, as we call him.
Sometimes when if you do searches as far as on the phone number or the company name or you may be able to find other ways to find them. I mean, if they're advertising it, we ought to be able to find the person. We might have to have someone propose to be a customer and have them come out, but
Well, that was my question. Did the email come from stateoftennessee.gov?
I believe so. If it came from our investigator, it should have came from his specific. I think he did that. I'm not sure. So that
Try a
is
few more things before we close it.
That's fine.
Is that agreeable to everybody? Try a few more things before we just arbitrarily close it.
I agree. Would you? I'm trying to think of a good way to propose this for the. Treat it as authorizing charges, then at that point, is that the most convenient way to?
Well, yeah, since they chose to ignore other warnings to stop or cease and desist, I would be agreeable to that.
So at this point, you've made the investigation. It does appear that there's unlicensed activity just from the advertisement.
Right.
So if we were going to make a motion, I would make a motion to issue a civil penalty for $1,000 for unlicensed activity. And you want me to go ahead and make that motion?
Yes, please.
And
So-
failure to respond.
Yeah.
We did notify them and they didn't respond. We don't necessarily.
We've never received a response from them. No, the most that basically our investigator got was just confirmation where the respondent said, "Yes, I got your email."
And I don't know that we would have much as far as failure to respond. That's really against a
For a
licensed
licensee.
contractor. So I make a motion to issue a civil penalty in the amount of $1,000 for unlicensed activity for the statute, or the 6232, 320, Frame B and 304K for design, advertising, and sales, and advice.
Okay, we have a motion by Mr. Cockcroft to authorize civil penalty for violation of TCA 6232, 320B, and 304K for licensed activity. Do we have a second?
Second.
All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Next, we have number 8, which is 2019-050551. Summary is the complaint alleged that respondent submitted a bid to install a surveillance camera system without having appropriate alarm systems license. Respondent has an active contractor's license and submitted a copy of the letter it received from the executive director indicating that it was exempt from the contract or the Alarm Contractors Licensing Act requirement based on its affidavit and contractor's license. And when I checked the other day, it is still an active contractor's license, so,
File the affidavit.
yes.
Okay.
So the recommendation is to close.
Make a motion to concur with council to close.
We have a motion by Mr. Cockcroft, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Excuse me just a moment. I made the motion. Who did the second? I didn't catch it.
Mr. Freiker?
Okay, I didn't catch it. Thank you.
We have number 9, which is 2019053141. Summaries the complaint alleged that respondent had an auto renewal provision in the contract between them for an automatic renewal of a 5-year term of the contract. Complainant stated it was never made aware that the contract automatically renewed for a 5-year term until after it attempted to cancel the contract, and respondent requested an early termination fee. Respondent provided documentation that complainant agreed to a 3-year extension of the contract between them and denied that there was a 5-year automatic renewal provision of the original contract. Respondent stated the extension was agreed upon over the phone with complainant, and respondent provided a copy of the written confirmation of the extension that it emailed to complainant after the agreement was made. Out of good faith, the respondent agreed to waive the complainant's early termination fee. So the recommendation was to close.
Do we not have a rule that doesn't allow anything longer than a 1-year?
That's correct. But the issue was complainant said it was an automatic renewal. Based on the contract, it was not an automatic renewal. They had a contract where it was actually agreed for that 3-year extension.
Well, a 3-year extension, but then they're saying it's a 5-year automatic renewal.
Respondent saying that there never was one. That was what complainant had alleged, though. And based on looking at the actual written contract, there was never language that there was a 5-year renewal.
Was there any renewal, or?
Not that was noticed in the contract, no.
Every contract should have some sort of renewal, even if it's month to month.
Right. I believe that the complainant thought it was a 5-year renewal because that they had just thought that that's why it was extended as long as it was based on the early termination fee that was being requested.
You don't feel like there was a violation of the renewal and the complaint?
Correct.
I make a motion to concur with council to close.
Second.
Okay, we have a motion by Mr. Cockcroft, a second by Mr. Richard to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we have number 10-019-056661. The summary is the complainant contracted with the respondent for monitoring services in 2015 and for a 5-year term set to end in August 2020. In April 2019, complainant agreed to extend her contract an additional 12 months to August 2021 in exchange for a discounted service job and for a medical pendant. Complainant decided to cancel her services and was charged an early termination fee. Respondent decided to waive the complainant's early termination fee as a gesture of goodwill. Even so, there's no evidence of any violation here, so the recommendation is to close.
Motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Cockcroft to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
And the last one, number 11, it's a representation of a previous decision by the board. It's complaint number 2018-013761. The original summary was that an anonymous complaint was made that respondent was advertising and selling security systems on a Facebook page. The complaint also alleged that respondent is a convicted felon. Respondent's Facebook page shows him advertising sales and installation of self-monitoring services. Also, respondent had recently began advertising a position open for an installer. The original recommendation, which was concurred by the board, was for to authorize a formal and send a consent order with the civil penalty in the amount of $1,000 for engaging in unlicensed activity in violation of TCA 6232-304A, which was the unlicensed activity. New information, the respondent signed for the complaint when it was first sent to him in April 2018. However, all attempts after that to mail correspondence to respondent have been returned to our office. New addresses have been found for respondent. Mail has been sent to those addresses, also been returned. Calls to respondent have also been unsuccessful. Respondent has never received notice of the decision by the board to authorize a civil penalty. The complaints or allegations were that respondent was advertising for installation services. Respondent appears to have removed its social media page for the business, and the owner of the business seems to have also removed all references to the business and alarm contracting services from his personal social media. Presently, there do not appear to be any offers or advertisements by respondent to provide alarm contracting services, and the name business appears to no longer exist. There was never evidence that respondent did any actual installations or sales. Although there was still a violation, as noted above, for the offer to provide services in April 2018, respondent appears to have taken action to prevent future violations by removing the offer to provide services. If we've been able to unserve respondent with notice of the violation noted above, the recommendation is to close.
Okay, if the board votes to close, what does that have as far as future implications if you were to find that this person was to start advertising again on social media?
Wouldn't have any implication on that. I would say if there was a new
Isn't
violation,
it from an active case to an
we-
active case?
we would treat it as a new complaint at that point, and hopefully we'd be able to actually get service and get contact with him.
Someone continue to spot monitor to see if this person's name came up on social media? Go into a dead file is what I'm asking.
I think it would go into a dead file. I mean, at this point, I'm following up on it. I'd been looking to, see on his Facebook. Couldn't find him. We had done different searches to find new addresses and everything we've sent. We usually send regular mail as well as certified mail, and the certified has been what's been returned to us, meaning he's not signed for it. He may have received the original mail. We can't really confirm if he received it or anyone else at that address. So
I know this may sound funny, but have you checked to see if this person's been arrested again?
I believe last time we did the specific type of search we do, it looks into that database as well when it looks at criminal history.
So it has been checked in the process to see if they've been rearrested.
It shows that, and we didn't find any evidence of that.
When they were alleging, we didn't have any proof that the person is a convicted felon to begin with, right?
Yeah. I mean, I'm sure somewhere along the way
I think that we had
it's kicked
confirmed that they
out.
were on probation at
Yeah.
some point.
Person been in the alarm industry working anywhere else or ever been licensed? Do we know?
Not that I'm aware of. From looking at it, it sounds kind of like an individual who thought this would be something he could make a little bit of money on. I would imagine he's buying cameras from a big box store and installing them that way, if he were to install them. But last time I checked, his social media said he was doing some other type of work. I can't remember what it was, but the business page is no longer there, and he had some other type of business linked to his social media. It was an alarm business. I can't remember
So
what it
he
was.
still has a social media page?
Only a personal one with his personal first and last name.
Maybe we scared him when he got a letter.
That's what I'm thinking, honestly, if he received that.
It's like, oh, I had no idea.
Mm-hmm.
I'll make a motion that we concur with counsel to close the case at this time and reopen if we find new evidence if somebody files a complaint again.
Okay. We have a motion by Mr. Fraker to concur with counsel. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries. Thank you. Next, we have the teleconference. Are we ready, or do we need to?
Well, could we just take maybe a 5-minute break?
Sure.
And we'll get ready. We're going to call the gentleman.
Okay.
Thank you. I want to go ahead and take a moment to read the material. The next one. It's going to be your Exhibit A, Ocean 10 Security.
Back to order. We're back on the record. Okay, I don't believe we're able to connect with our teleconference, so we'll move on down the agenda. Next on is the appearance, which is Exhibit A, and he's not here either, I believe.
Yes, ma'am. The teleconference, we have been unable to reach him, so I'm going to put that at the end of the agenda, and we'll try again unless the gentleman calls in. The appearance was Mr. Levy Evans. You had requested his appearance. You talked to him at the last meeting by telephone. He agreed to be here along with his QA. They are not here. I would like to have your authority to look at the application, and if deemed necessary, would like to go ahead and close this. The gentleman is still on probation,
Okay.
but I'll take a look at it, make an administrative decision on that if that's okay with the board.
Motion to allow her to close this application, please.
It's me.
And when you say close, we're going to close basically as a denied application?
Well,
Or
the terminology, yeah, he's not being denied because of his criminal record. His application's being closed because he cannot meet the requirements.
I'll make the motion that we close this application due to failure to appear and can't meet the requirements or something to that effect.
Okay, we have a motion by Mr. Fraker to close based on his failure to appear and his inability to meet the requirements. Do we have a second?
Second.
And a second by Mr. Richard. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I believe we're down to the administrative matters now. You have your monthly reports. You have your June and July. So I was just going to, June is the same as July. I was just going to look at July 2019. We don't have any legislation. My normal monthly meeting with the attorney and Jesse Gentry. I have my monthly financial meetings, which I'll talk about in just a couple of minutes, and we only had one complaint.
Does anything happen with from the sunset hearing, the possibility to?
I have
Go back
not
before
heard
then?
anything from the Hill. We're still taking a look at that because we're still supposed to be up there in December. Working internally on that. It's okay now. We'll go to the budget review. Most of you have been on the board for a while. You do understand we start July the 1st with a zero balance, and we have to end with a positive balance at the end of June. Whenever the state closes out at the end of the June, we have 3 or 4 different periods that we will go through before we get to the final balance. But right now, your balance is $149,994. So you are in the black. You are holding a reserve of $2,258,262. We're pleased to know that we are in the black. I have not seen any problems with your budget. Don't anticipate any problems next year. The Hill, I believe, wanted to discuss more, which we don't actually have anything to
Control
do with the
over?
reserve. Yeah, I don't have any control over it all, but yeah, we'll be going to the Hill to explain that.
Basically, you can't buy a printer, but you have $2 million in reserve.
There you go. Thank you, Scott. I just love you. Yes, that's basically what that is. But I did want to advise you, I don't know the date yet for the December, but they may require all board members to be there. We will let you know just as soon as we hear anything on that. You have anything? Right. This didn't want to hold for some reason. We did the review, and there's no legislation. Request for an extension. You have a request from Select Security. I think they were just a little confused about the request, but your next meeting is not until October the 17th, and then the next one would be December the 12th, so we wanted to make sure we got this in just in. They did ask us about the extension to replace their qualifying agent. They have 10 days to notify us, which they did. They have 30 days to name the individual, and they're going to replace the individual. I've asked for another. I have granted the extension, the very first one. They wanted to go ahead and ask for the second one in case they didn't meet within this time frame of our board meetings. The gentleman is still needing to
Have somebody lined up they're working on.
Yes, sir. They have the individual that they want to place in there, which you have on there, but he hasn't taken all the exams yet. I was rather concerned about it. So there's only one exam center within 80 miles of him, and they're supposed to be closer than that. So I don't know where he was at, but his next exam's not until the 10th. September the 10th. So he's going to either hit the October meet. If he didn't pass, for instance, he'd have to come back anyway. So an extension so he wouldn't fall in between those board meetings.
I think they're just being safe versus sorry.
I
I
do,
don't
yeah.
have a problem with it.
Make a motion to grant the extension requested.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Cockcroft to grant this request for a second extension for the person to take test. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Oh, okay. Before we move to the next item, I'm sorry. I should have told everyone at the beginning of the meeting. If there's anybody in the audience that wishes to speak, they do have that right. There is a sign-in sheet here for anyone who wishes to speak. The only requirement I know of is that we have always asked if you do speak, it is something that is on the agenda. That is so the board would not be asking any off-the-wall questions and they hadn't had time to speak on or to study on. That's just an announcement that I needed to make. We have a visitor. We're always glad to have visitors. We like to have the QAs or any registered employees that wish to come in. This is an open meeting and anyone can attend. Anyone can speak. They just need to sign up. They don't have to let us know in advance. We do ask if they know they want to speak that they tell us in advance. But if they do come to the meeting, there is a sign-up sheet. They have the right to speak. Thank you. Yes, we're going to go to the criminal histories. That should be Exhibit A. You got Mr. Bridwell. I'm just going to give you, while you're looking at that, just give you a brief rundown. We're going to start with June of 2009 for shoplifting, misdemeanor conviction and probation. November of 2009, aggravated assault, misdemeanor conviction and probation. 15 and 16, he did have some driving difficulty. 10-5-17 was domestic simple assault, reduced down to assault, misdemeanor, probation. 216-18 domestic assault, simple, marked down to aggravated domestic. 223-18 violation of probation. His probation was revoked. He had to serve 100 days. 227-18 was harassment. 930-18 violation of probation. You may see other things on there, but I just hit the highlights.
Probation still current? Is he still on probation?
Yes, sir, because he's violated the probation in 930-18 for the harassment and the domestic. He did have, from the document, he did have looks like a probation here in January the 10th of 19. I don't have any information
At
on.
what in 19?
It says probation violation 723 of 18, filed 724 of 18. Next hearing was January the 10th of 19, and I don't have anything after that.
Realize there's a tremendous amount of information to look at here, but just on that fact alone, we have denied in the past if they're still on probation. I'd like to make a motion to open up for discussion.
Go ahead.
I'd make a motion that we deny this registration based on, one, the recency of the charges and his criminal history, two, character, and three, if he is still under probation, that would be an automatic denial as well. See where it lists the probation time expiration, but where our assumption is that he is still under probation.
Oh, just a moment. We're looking this up on our core system, so if you wait. Information.
It's a little round.
He did. It goes right back to it. It's hung in cyberspace.
Programmed for
certain words. Companies Berg, Fire, and CCTV. That's what we wanted to see. His application does not tell us what he's going to do, whether he's going to be at a monitoring company station or whether he's going to be into sales. Exact what we were doing. So whenever we were looking at
The fresh start criteria.
we were trying to determine what his position with the company was, but I'm not able to tell that.
But they're not licensed for monitoring, so he wouldn't be in a,
It wouldn't be monitored, no.
most likely it would either be sales or installation. So he'd be in the field in the customer's homes.
Hey, we have a motion by Mr. Harvey to deny his application based on the fact that the charges are so recent, his overall poor moral character, and the fact that he is possibly still on parole from the 119 probation violation. Do we have a second?
Second that motion.
And a second by Mr. Fraker. All in favor, voice by saying aye.
Aye.
All opposed? The application is denied based on those facts.
Thank you very much.
Okay, next,
Next would be Exhibit B. I pronounce that me water. You can go ahead and look at her record. I did write down a few things. 42710, wandering and prowling to obtain Schedule 1, 2, and 3 drugs. She received a felony conviction of 3 years.
when was this?
427 to 10.
Okay.
5, 6 of 10, they convicted her of theft by taking, which was a felony conviction, and gave her 3 years. There are some others that you see on there, but they were dismissed, so we're not going to be able to look at those. Her position is for a monitoring representative. After looking at these documents, we were able to determine that her probation should have been finished in 2016.
No, 6.
It would have been 6.
2010.
Each charge that Cody read into the record was 3 years. They ran concurrent, so they would have put the end.
I'll make the motion that we grant this lady her alarm license, a registered employee for a monitoring center. Due to the age, it was almost 9 years ago. No other criminal history, just this one incident. And according to her account, of course, he said, she said, but
Okay, we have a motion by Mr. Fraker to grant this employee registration application. Do we have a second?
I was second based on her explanation of the events that unfolded.
And a second by Mr. Harvey. All in favor, voice by saying aye. Aye.
Aye.
All opposed? The motion carries.
Thank you. I believe we're down to the education.
They're not on the iPad, correct?
ours goes only to 10.
We don't have education on ours. They end with the criminal histories.
Okay. Well, we can deal with this.
Take a break.
No, we got this. But individuals will send the courses. So you should be able to discuss these courses without seeing it on the iPad. Just trying to cover this. Keith, you just had that one. Edwards/KIDDE. KIDDE FX-64 and 1000 intelligent as de-dressable panel. That was, they wanted credit for 8 hours of continuing education.
8 hours of continuing ed, yes.
Oh, you want to go to yours?
I had the NAPCO classes.
Yes.
And those were good for continuing education. I think what they had submitted was continuing education as well, and they're good for that.
All right, let's go ahead and put this in the record then for Scott. It's NAPCO, NAPCO Security Technologies, GEMC-INTERATED Systems. That was 4 hours of continuing ed, and we will give you a copy of this. Sure. NAPCO Security Technologies, they wanted 4 hours for that one. NAPCO, that was GEMC Programs and Operation. The next one for 2 hours was NAPCO iBridge Video, 2 hours. The next one's NAPCO for Starlink Lightfire. They wanted 2 hours for continuing. So you agree in all continuing education. Very good. Doug, I believe you had something there.
I do.
All right, you've got Southeast Security Products, Video Management Made Easy. They wanted 1 hour.
Works for me. A whole 1 hour.
The second one is Access Communications.
Correct.
They wanted 2 hours of continuing education, did not provide us with a certificate. We were not able to get a certificate. The gentleman that we spoke to didn't quite understand why he had to submit these, but we did not get a certificate to show it to you. But he wanted 2 hours of continuing education.
That's the one from Chase Whitby.
Access Communications.
Because I had two Whitby brothers, and that's what got a little confusing, because I got the second one. Knowing these gentlemen personally, I have no issues with the courses that they've got, so they look good.
Lou, I believe you got alarm monitoring services. Employees can make or break a business. 2 hours of continuing education.
I did, and looks good.
Oh, okay. Going to approve that one?
Mm-hmm.
Looks like all continuing education was approved by the board. Can I get a vote?
Buck. Motion.
Make the motion that we approve the continuing educations.
Second.
Okay, we have a motion by Mr. Fraker, a second by Mr. Richard to approve all the courses presented for CEU. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Well,
That's why.
we still did the education, the one we went ahead and got those out of the way there. We do have a gentleman who wants to come back and speak before us again, Roy Pollock.
I think
You-
were those denied last time.
Courses that you denied at the last meeting.
Was anything else submitted, or, because what, the paperwork I got was the same paperwork? Okay.
I believe Roy said he had some handouts.
Yes. Can I just read my statement into the record first, and then do the handouts? Good morning, ladies and gentlemen. My name is Roy Pollack, P-O-L-L-A-C-K, and I have reviewed the video recording from the meeting held on June 20th, 2019. I prepared this reply in response to the concerns and questions raised during that meeting. First off, Comcast University has been approved as a Tennessee provider since February of 2016, provider number 122. Stay Safe Enterprises have also been approved as a Tennessee provider since February of 2016, provider number 123. Comcast has 4 courses approved by this board at the present time. Stay Safe Enterprises has 1 course approved. I am an approved provider and an instructor in over 12 states, including Tennessee. There are 8 different submittals that you have. The reason for the 8 submittals is we did 2 courses, one under Stay Safe Enterprises and one under Comcast University. Each one of those was done as an online course and as a classroom course. The reason being that some states issue different numbers for online and for classroom. If that's not the way that Tennessee wishes to do it, I'd be happy to take the approvals for both as one number. A concern was raised about the material provider. I reviewed Rule 0090-05-.02 and complied with the specifications therein, as well as answering all applicable questions on the application. To address the issue of commingling of the paperwork, these applications were submitted electronically. How they were printed, I am unaware and apologize if somehow they got mixed up. I have prepared an organized binder for you to review, and I'll be handing that out in a second. Each application was submitted for continuing education, not for initial certification. Comcast employees will register for the course at no charge using their Comcast email address. There is no reason to think that any Comcast employee would go through the Stay Safe Enterprises portal and also pay for the course. Other persons that are not Comcast employees will register and pay for the course through the Stay Safe Enterprises portal. They in turn will not be able to access the course through the Comcast gateway since they will not have a Comcast email. This course has already been approved in 8 other states and counties throughout the country. And I have a presentation to give each one of you.
If I remember correctly, and the board members correct me if I'm wrong, there wasn't a problem with the courses. The only question was if Comcast employees could take the courses internally and externally and receive CEUs ×2 for taking the same course. Is that correct?
Well, there was that issue.
Yeah.
And then also, I thought that it was checked for initial certification, but
Copy I received was that I reviewed this.
Then it
past-
was an issue also for, not just for continuing education, but for initial training,
Right.
correct?
I think that was one of the main issues,
Yeah.
was it was for initial out.
I'm looking,
in my opinion, and I don't, the rules, you may be complying exactly with the rules, but a lot of the courses that are submitted do submit a lot more course information. Your course information for an 8-hour class was about a page or a half a page. And it was a synopsis, and maybe that's sufficient. And I've never taken one of your classes. I know you in the industry, and I know you to be an upstanding person. I've never taken your classes, probably teach great classes. But some of the others that we've actually seen a full, one of the NAPCO classes, it was a complete PowerPoint, everything that went with it. Some of the other online people will present links to actually go see the class. It gives us more information. And maybe what you've presented is sufficient. It was a little overwhelming with, not understanding why you were trying to present, because, 8 classes, to me, I start looking through it and it's like, okay, well, this one, and then this is the same thing. Well, this is the same thing. This is, it's like, if it had been outlined, maybe it would have been a little easier to understand that, because I literally don't print them out usually. Yours, I had to print them all out and lay them out and try to figure out where all these pieces of paper went, because I was like, these are all the same. Why do we have 8 classes and it was 2 classes instead of 8, but it didn't look like there was a lot of meat in what the class was. Maybe I'm being a little picky on that, but
so I have printed out the 2-hour course right here, if you'd like to take a look at it and skim through. I only have one copy, and I have the 8-hour course right here as well. Ms. Vest, would you like to hand this to Mr. Cockcroft? And you can thumb through that. That's pretty much the meat of the information.
I'd like to make a statement that I'm going to recuse myself, as Roy and I are coworkers at Comcast. Thank you.
the other issue is the multiple classes with the, it sounds like you've answered the issue with Comcast employees versus other employees that they wouldn't be allowed to take the same tests, but you do have an online and offline version of the class as well.
Okay, this is what was the question that you had there.
But then this copy doesn't have that, so, and that would be a lot more appropriate to look at it for continuing
And this one
ed.
also was all checked.
Right. You're looking for continuing education on all of
You've
it.
already approved.
Because it's not, since they didn't get copied over to the iPad, they don't have that information. And I did copy. Hold on.
I will just say that we have a 35-hour course, because that's the length of our certification for an internal employee, which you've already approved for initial certification. So any further classes that would be submitted would always be for continuing education.
That was a clerical error or whatever he's saying he
He's-
wants
he-
to submit for continuing.
And I believe that's the only box checked in any of the ones you have now.
This package you just handed out, that's correct, that's all that's checked, but the original one we got all 4 boxes were checked.
On some of them, on some, actually, that's what I was just thumbing through here, because where Shauna sent it.
It did look like a couple were and a couple weren't.
Yeah, a couple were all 4, and a couple were only continuing ed. That one's continuing ed.
Well, on this page, it's got 8 hours, burglary, fire, CCTV, and monitoring, but it's got up above it, continuing education. I think this is where the confusion's coming in.
Well, I believe it fits in every category. But it's only for continuing education. It's not the initial certification of an individual to receive their
If
licensing.
you just check continuing education, I think that would cover.
And that's what he's done now, and the categories are fine. They haven't been requiring the categories on what's submitted. I mean, it's bravely outside of the area.
No, I believe Madam Chair is correct. Well, we got confused is, for instance, this one here says 8 hours for continuing ed, but it's marked in all classifications. So is it 8 hours of continuing education in each one of those classifications, or is just 8 hours of continuing education?
It would be 8
Yeah,
hours. It
just
could be
8 hours.
used in any of those.
Just 8 hours.
It's just
It doesn't
8
matter
hours.
what you took. Okay,
Right.
that might be
If you
some of the
if you only
confusion.
hold your fire license, you can use this 8 hours. If you have a CCT, you can use your 8 hours, or if you had all 3 or 4, whatever, it's still just 8 hours.
How do we handle the administrative part of an online and an offline class with the same?
I don't see where there's any difference at all.
For continuing
If
ed.
it's continuing ed, if it's approved for continuing ed, it's approved.
So
There's
you
no
would,
We've
difference.
never made a distinction.
There's no
that
account
way.
number or
It's
course
going to have
number.
a course number. No, I see what you're saying. If you have one company submitting a course and they're going to do it online and in the classroom, no, it'd have one number. It's one course.
One course.
so we could approve 4 of the courses for both instead of approving all 8. I think that'd be.
Correct. And again, I did that because most of the ones we submit to different states,
Want it that way?
they either allow you only, because I'll take North Carolina, for example. You need 8 hours of continuing ed, 4 in classroom and 4 online, or 8 in classroom. So they issue different numbers at different levels, so, and that's just one example. So if you just want to issue one number and it covers both, that's how you do
I
it.
think that's better for us administratively. And then if we're not doing any initial application, then the proctoring and all that doesn't matter, which that was a concern of mine if we were doing some of the online. So
Okay, we took a look at the certificates, and Roy has sent in a certificate for online and a certificate for the classroom, for instance. We can do that. If we need to, we can, if the board wants us to, we can break it out. We already considered it one. We give it one number. But if you're talking about now looking at people that want to do online versus classroom or however, and give them 2 separate numbers, you still got the same course.
my concern, and this may be silly or unfounded, it's like maybe it's not a problem that somebody's going to take the same class, but if someone taking one class online and
Online,
one class
then the
in
other one's a
person
uh-huh.
and submitting the
Both
two.
certificates for the same course.
Right. Personally, I'd
can't do
prefer to
that.
have one number that could be submitted for online or in person.
So it would just be a matter of Roy just giving out whatever certificate they need, and they
Right.
would send it in. That course is approved, we're going to take it however you took it, online or for the classroom. We can do that, yes.
I can alter the certificate to meet, as you see, there's a lot of X's on there because of course number, dates, and stuff like that.
Right.
I can alter the certificate issued to match your final determination, doesn't matter.
It doesn't matter to us whether it's online or whether you're sitting in a classroom. It may for you as the teacher, but to us, I don't
For
see
continuing ed, it doesn't, but
Continuing
for initial
education.
application,
Yes.
it does.
It has to be proper.
Because I think you had some proctoring and other stuff in it, or some that's
I don't-
not really required on continuing ed.
Our online courses are managed through a portal that checks who they are, and there's gatekeeper questions throughout to make sure that, an individual didn't sit down, and then I took over for that individual and finished it up.
I think what we're going to need now is, since it was denied at the last meeting, we're going to need a motion to approve these courses as they were presented today. That's what you wish to do.
That's fine, as long as the course material is, or the certificates are submitted to where it's how y'all need them to calculate the courses.
Right.
Or it's done in a manner that's not confusing or duplication.
We don't, as far as administratively, we don't care if it was online or in the classroom. If we get a certificate, it has that number that has been approved and that course has been approved, we're going to approve that.
We're okay with the
Okay.
courses, it was just the.
Oh, okay. In the manner they
It
were
wasn't
presented.
the courses weren't the problem, it was the paper, the way the paperwork that was submitted
Well,
that.
Well, I submitted too
And we
much.
didn't have the full class. He's submitted.
No, I
Right.
mean,
Well, we had too much of duplicate stuff. This, if you'd have sent us this in electronic, that would have made life easier for us.
I'm just saying,
But you
since
wanted
it
to
was
come to
actually
Nashville
denied
today.
at the last
Of course
board
we did.
meeting, we will need
I
it.
don't think you're recused from looking.
Well, I'm very careful on the electronic distribution of that due to,
We won't even let you look
You
at
can
the
see it.
courses. No. Hey, we won't even let him look at this. No.
Okay, Scott, you've got the ones there. Let me put my glasses back on, or went out supposedly to everybody. The Comcast University, understand the low voltage requirements of NEC. 21st Century Communication from POTS to MFVN. 21st Century Communications, again, one was online and one was the classroom. That's where we got confused. We considered it was just one course, all right? You have Stay Safe Enterprises, understand the low voltage requirements of the NEC 2017, 8 hours. And yeah, that's the same. 21st Century Communication from POTS to, and that is POTS, to M. And when it's the classroom. That's where we got confused.
I would make a motion to approve the 4 online classes to be online and in person as presented, all for continuing.
Second.
Okay, we have a motion by Mr. Cockcroft to approve the courses as presented for online and in person. There's 4 courses total, but in different formats.
Well, there's two courses, and they're submitted as 2 different companies. And it's whichever one, I'm not necessarily saying you have to present the online one in the classroom format or whatever. I'm just trying to word it somehow to approve them for both.
Courses as presented are
Right.
okay.
Right.
And seconded by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? And let the record show that Mr. Richard did recuse himself from any discussion or voting.
Let me ask you, Roy, when I get these certificates, are they going to say Comcast University, and then the other one's going to say Stay Safe?
yes.
Correct. Okay. And it's not going to make any difference to us if you put it online or whether you say classroom or her.
You could note it on there, but it
For
doesn't matter.
him, but I mean, for us, we get the certificate, we're going to accept it.
So you're
okay.
going to issue 4 class numbers.
Yes,
Okay.
just 4.
So I do have one more question I'll address to you, Mr. Cockcroft, is that course is for the 2017 NEC. The 2020 NEC is coming out very shortly. Some states would require a revision to that when it comes out. Obviously, we're just simply going to update references in there. Do I need to resubmit the course to this board saying 2020 now, or it's still the same course with just some revisions? Would you like it sent to you again for another, and that might cause another course number too?
Right. Well, and you could. I mean, if somebody took the 2017 and you made a new course for the, they could take that other class again if you wanted to submit it again. And there's not a cost to submit or anything. You don't have to, when we understand what we're getting next time.
Let me ask you this, when the 2020 comes out, would there be, remember, I'm public, okay?
I know.
Would there be any reason for you to still offer the 2017? Wouldn't you want to go to the 2020 version and do away with the 2017?
Well,
I mean, I'm trying to figure out if it would be more simple for you.
we're in the city of Nashville right now.
Yeah.
And Nashville is still on a 2002 code. So, yes, there is a reason to still offer other versions of the code. Many municipalities, cities, states adopt different codes at different times. I've had a discussion with the chief fire marshal in the city of Nashville, and they're staying on the 2002 code for now. And that's 5 cycles back.
And I think you're going to have to submit a 2020 then, just based on what you've told me, if different cities are still operating at different.
That's fine.
And that would get a different course number. There'd still be
Right.
people out there taking the 2017, and they could be somebody out there want to take the 2020, so it's going to be
Don't y'all think if
different
a
course
city
numbers.
adopts the 2020, then that need to be sure their people are taking the 2020
Right.
course?
They can still take the 17.
I'm
Well, I
sure
mean, they
Roy would
could,
come
but,
back
I
with
mean,
that.
it'd be just take the one course, and if that's what their city's operating off of.
But there could be somebody that's operating off 2017 code 10 years from now, and there could be somebody operating off the 2020 code.
Right.
10 years from now. We would prefer that you resubmit it if you're going to do a 2020 code.
Fine.
Yes,
And it
that's what
should-
I'm saying.
And it
Just
should
to-
be, it shouldn't be a large task. I mean, it's just a matter of, it should be easier to prove now.
I can do that, and that's why in the title of the course, it says the version of the code. It says 2017 code.
Right.
So the new course would say 2020 code.
Thank you. You want your books back?
Not those, just the courses
I like
themselves.
these,
'cause I can't get through. Court here.
Okay, we finished that. We did get correspondence back from the gentleman that we tried to call. Apparently, we have missed his window. We did attempt to call, but apparently, when we said we would call back later. He has had another appointment he had to fly out to. So,
Would we like to discuss it
but
as
you
the
could
information
still
we
just,
have?
yeah, I
Is this the
think,
teleconference person?
yes.
Okay, not the
Not
other
the
one.
criminal one, no. Okay, if you would, now, I might not even needed to bring it to you. It's just there was some correspondence from it, and when they started asking me questions, why this, why that, why, and I said, okay, well, let's ask the experts in this area. It says here that Ocean 10 Security manufactures the TSUNAMI camera system and sells
Oh,
to
man.
camera system and sells to government agencies only. Waiting, okay, there was some mix-up of us getting the actual documentation. Well, let me get to my second paragraph here. It's manufactured and shipped to our customers to be placed on pre-existing utility poles. So the first question was, who climbs that utility pole? I didn't think alarm people climbed utility poles. I thought that had to be utility
Utilities.
people, but anyway, with no installation required by us, similar to the Ring doorbell. The system is connected to our 4G modem by way of our partnership with Verizon. Ocean 10 Security does not monitor the camera system in any way, nor can we since the customer has full access. In the case of tech support or retrieving video, Ocean 10 either sends an online tutorial explaining the process of retrieving video, or our tech support will talk the customer through the process. The one piece of the system that we do have access is to the 4G modem. Just as every other cell phone carrier and or local internet carrier has remote access to their modem, not necessarily the devised connection to the modem. It is our understanding that we do not fall any of the provisions of the Tennessee Alarm and CCTV regulation, just like the manufacturer, Ring Doorbell, or any other camera manufacturer. We'd like for your office to state this before we ship another Dasami system to government agencies in Tennessee. Well, I couldn't give them a statement.
So in a nutshell, they manufacture, they ship it, and it's up to the,
And it sounds like they're primarily sending it to police departments or municipalities. I would see it not falling under the law. I would see it being exempt. I agree.
All right, would you, I'm sorry, I'm sorry, we were talking because I was saying, well, all they were doing is shipping to law enforcement. Would they be required to have a license to do that? But what he's saying here, we're going to stop all this shipment until you tell me it's okay to ship it. So I said,
Right,
I need to ask.
he's wanting to err on the side of caution, and he doesn't want to ship any further if he thinks, if there's a possibility he's in violation.
And I will just say, for the record, Cody and I did speak about it, and we came to the same conclusion the board did, but we're not the board, so we don't have the authority to tell him that it's not a system and he can go forward with his business, and that's why we decided to bring it to you all.
Anything further, it's not necessarily a motion. Does the board agree?
Well,
Is there any other-
I'm going to need to send him an official letter from the board that says
It's not
this is not an alarm system.
Well, not a system.
I think if we just make that statement on the record, I don't see where we need a vote on that. I can do that, long as it's on the record
I don't know if
that
I
we
would
agree.
use those words. I might say that it just does not fall under our requirements for regulation.
We'll be real particular with the words we use, thank you.
Ashley.
Yes, she will. So, I stand corrected there, all right. I believe, Madam Chair, I don't have any unfinished business or any new business unless the board has any. And if we don't, I'll be subject to adjournment if it's up to the board. I know.
Any new business? Any old business? Our meeting is adjourned. Thank you.
I hope that wasn't too hard.